In Watertown, New York, people are outraged that a man who pleaded guilty to raping a 14-year-old girl won't be serving any jail time. Legal journalist Molly Barrows with the Trial Lawyer magazine joins me to talk about this. Yeah, I don't know. This is the most vulgar story. It's vulgar on so many levels.
It is.
But to me, here we have a 14-year-old girl, and the judge says, well, we're just going to give this guy probation. What was the rationale that you saw here? I looked for it and I couldn't find the rationale.
Yeah, I know. Well, I'll outline the details of the case for you, and then we'll get into a little bit about, so that helps explain what their rationale was. But essentially, this guy, Shane Pish, was sentenced to 10 years probation, and he pled guilty to a third-degree rape charge. His initial charges had been raping this 14-year-old girl he had met when he was a bus driver for the Watertown City School District, and she was a student on the bus. Now, the alleged incident, or it's not alleged, he confessed to it, happened at his home. He was also charged originally with, I think, providing alcohol, contributing to the delinquency of a minor basically by providing her alcohol. And apparently there had also been 2 other girls there as well, and he had initially been charged with providing them alcohol too, but that charge didn't show up. I don't know if it was dropped or what's the situation. He was 26 at the time this happened.
Oof.
So so essentially he ended up pleading guilty to this, and as they're going through the process, they had charged him as a sex offender, but only a level, the prosecution wanted a level 2, and the judge said no, it only needs to be a level 1, because they ended up knocking the charges down to where it was just her. She was the only victim. These other 2 girls that he allegedly gave alcohol to, those charges weren't brought before the court.
Forcible rape, or was it?
So it was basically saying that the DA said the only reason they were pursuing this to a great extent is because that was the law. They had to, she wasn't of legal age to consent.
So it was an age issue.
It was an age issue.
And the judge thinks, oh, well, that's okay, and we're just going to...
And what I read between the lines, as in various other reports, was that they're essentially, in a way, yes, because she wasn't disagree. She just because she was not of the age to consent didn't mean that she did not consent.
Right.
And so that was essentially, they're saying it's almost a way of saying she asked
but that's
for it.
You see, that's the policy. The policy argument is that there is an age of reason and an age of choice. And anything below that age, whether it's 17, 18, anything below that age, there are plenty of studies. They didn't just arbitrarily come up with this law.
Right. There's a reason
there's
that
a reason.
exists.
They've studied the idea. They've studied when can a child make an intelligent decision. When can a child determine that this is what they want to engage in? So it's not just somebody, they just didn't pick a number out and say, hey, let's make it 18 or let's make it 7.
There's a reason that age exists, right?
Doesn't happen like that. So this judge, I can't imagine that he's not under pretty serious scrutiny. What's the outcry on this?
So James P. McCluskey is the judge. He's the one that decided that the level of sex offenders should drop from a 2 to a 1. He, made a number of comments that basically would imply that he felt like that there was, because the guy had no priors, that he felt like that level needed to be dropped as well. There's 50,000 signatures now wanting this guy taken off the bench because of this. People are outraged. The victim's mother is outraged. She said, he took something from my daughter she'll never have back again. Now she's dealing with depression and anxiety. And the impression that you get from the DA's office as they defend this judge's sentence was that, hey, we actually did her a favor. If we had initially charged him under the higher level rape charge that we were looking at, which did have similar sentencing guidelines to the one that he ended up pleading to, if we had charged him under that, she might have had to have testified. She would have had to have testified before a grand jury as well as at trial. So going back to your point, it's almost like, hey, we know that you were raped. We know that you might have consented, but you're not of the age to consent. Yeah. So we're just going to save you the trouble of testifying.
Yeah, and see, those are the operative words, age of consent. Again, this isn't something that somebody just arbitrarily picked out a number and said, it's this number, and here everything below is below the age of consent. They've studied it, and they've figured out what is the impact to a young lady in later years. When can she really consent? Obviously, 13 and 14 is not an age of consent. And so I think they really need to treat this judge very poorly in this, and I hope they do.
I hope they do as well, Pap. We're going to continue to follow it and see what becomes of this petition and the public outcry in this case.
Yeah, because it sends a heck of a message to the rest of the public, doesn't it?
Absolutely, and we certainly know the patterns with people like this, often cases.
Yeah. Molly, thanks for joining me, okay?
Thanks, Pat.